Let's start recording this webinar, and I'm going to turn it over to my colleague, Megan Guevara.
Thank you, Beth. Welcome to everyone again. I'm Megan Guevara with the Pretrial Justice Institute, and today is a special event because this is our first crossover between our two communities. So welcome to those of you who are joining us from the University of Pretrial, which is our criminal justice system focused pretrial community, and those of you joining us from JDAIconnect, our youth justice focused community. And you're all welcome to join the other one if you're curious about what goes on in either community. And we brought you all together today to talk about the question of money bail and looking at how it's being used nationally in the juvenile court. I'm joined by my colleagues Anissa Khan and Marianne Scally from the National Juvenile Defender Center, who are going to be talking about some research and resources that they've put together on the juvenile justice side. And then I'm going to be talking about what are some of the lessons learned we've had in the fight against the use of any type of money bail in the adult system. We welcome your questions at any time during the session. Feel free to pop those into the chat box, and Beth is going to be keeping an eye on that. And to start off, we're interested in finding out who has joined us today. I'm going to try to see if I can, there we go. Oh, there's us. And we're interested in hearing a little bit more about you. So Beth's going to pull up a poll question. And if you can let us know who's on the call today. Are you a defense attorney, a reform coordinator from either the youth justice or adult justice system, from probation, detention, or jails, a prosecutor, a community member, or other? And it looks like we've got a lot of people already popping into the other category. So if you'd like to put in the chat box what other you are. If you hover over your screen, you should have a button up in the top left-hand corner where you can hit chat, and you can use that button to communicate with us at any time. We have a federal policy advocate. You can also use that button to send us any questions. We will make sure we leave some time for questions at the end of the webcast, but you can join us at any time. We've got the Casey Foundation on there. Opal is representing today. Welcome.
Megan, we have 75% of the vote. You let me know when you'd like to close this.
All right, feel free to give that a close. We've got a JDI coordinator on there, policy advocates. Awesome. All right. So it looks like about half of you fall into that other category. We've got a good number of defense attorneys and reform coordinators who are represented on the call today. Also, a state bail administrator is coming through in the chat box. Thanks, everyone. We're really glad to have some diverse representation because, as you'll see through this conversation, there is definitely a key role that defense attorneys can play that Anissa and Marianne will be talking about, but there's also a place for virtually everyone in the system to be able to exert some pressure about how bail decisions are made. Then we have a couple of additional questions for those of you who are working in the youth justice system or have some role in the youth justice system about whether or not you're seeing money bail being used. So the poll question number 2 that's about to pop up, is money bail an option in your juvenile court? We know that in 19 states, money bail is allowed legally. For those of you who are on the phone today, looks like we've got a mix there, a few people who do not know. Give another couple of seconds for that, Beth. We can probably close that poll up. So we've got a little more than half that are saying yes, and several folks don't know. So that can be your homework for after the webcast today to see whether your state falls into that bucket. And then the next poll question, most relevant for those of you who said yes, money bail is an option. Do you want to go to the next question for me? There we go.
I'm doing my best.
Whoops. I think it's a little slow for me. Do you see money bail used routinely in your juvenile court? So for those of you that have it as an option, there we go. Yes, no, or don't know. Looks like so far about half of folks are saying no, they're not seeing money bail used routinely. All right, Beth, we can probably close that poll.
Okay.
And it looks like we had a little more than half of folks saying no, they don't see money bail used routinely, but about a quarter who are saying yes, that money plays a role in their juvenile justice system. So thank you for participating in those polls. And now I'm going to hand it over to my colleagues from the National Juvenile Defender Center to talk about their research and the strategies that they would like to share about addressing money bail in the juvenile court.
And we'll just
Anissa,
say that
Marianne?
if the poll is still up on people's screens, they may have to exit out.
Oh, thanks, Beth.
But some people need to still close that.
Great, thanks so much. Thanks, Beth, and thanks, Megan. I'm Mary Ann Scally from the National Juvenile Defender Center, and I'm here with my colleague, Anissa Khan. And we're really grateful to all of you for tuning in today to talk with us a bit about the use of money bail in juvenile courts. At the National Juvenile Defender Center, as our name indicates, we're really focused on what happens to young people in the delinquency system. And Anissa is going to start us off today talking a little bit about what we've learned about the use of money bail in juvenile court.
So the National Juvenile Defender Center, a few community members, so our community is, a large percentage of our community is made up of juvenile defenders across the country. And some of those defenders reached out to us and they wanted to know, what does juvenile bail look like across the country? And we didn't know the answer to that. So we created a qualitative study. So we reached out to 82 defenders across the nation, at least one or two, depending on whether bail was allowed by statute within a particular state. And we asked them what the practice was in their jurisdiction. We released this report, Right to Liberty, Reforming Juvenile Money Bail, based off of those responses. We followed up with interview questions about the practice, and our findings are based off of those interview questions. And so what we found across the state is, across the country, is as of April 2019, 19 states have statutes on the books that expressly allow the use of money bail in delinquency court. We found that 9 states expressly prohibit the use of money bail across the country. And as you can see, as defined by the map, most of those comes from legislative statutes rather than court rules. There's one state, Minnesota, that allows the use of cash bail by court rule, but other than that, it seems that most of the ability or permissible use comes from statutes. So for our findings, I think there's a lag in the system.
We're going to ask Megan to advance to the next slide for us.
Or Beth.
Yes, I will take over here. How's that?
Perfect.
So my theory is, there we go.
And so what we found across the country is that where bail is a legal right, it's often not a reality. And so what that means is, let's talk about what bail is. Bail was intended to be a right to release. It was the court allowing somebody to be released with some condition or no condition at all. So release on recognizance is one form of bail. And what we found with our community is that many defenders did not understand this to be the local practice. So where bail is a right, it's often not a reality. We found that many courts were in fact keeping children detained on unaffordable bail as a way to hold them in detention. And sometimes that was based off of a misunderstanding or misperception of the child's home condition. So in some communities, if there's only one parent in the home, the courts interpreted that as being a lack of supervision and would hold a child in detention on unaffordable bail, knowing that that child and their family could not make that amount, as a way to keep that child detained and under the court supervision. We also found that courts regularly impose unaffordable bail Courts too often impose bail as a means of ensuring detention, so a little bit of that comes from that misperception of the child's family and their community. Bail frequently encourages youth to plead guilty and waive their trial rights, so we found that when a young person is detained and they're removed from the community that provides the support system that they need to promote adolescent development, they often will decide to plea to an offense so that they can be released from detention as a way to get back to their home and their community. We found that bail contributes to the disproportionately high number of youth of color being detained. So one of our questions had to do with race equity. And what we learned is that youth of color were more often given higher bail amounts that their families could not afford, and they were kept in detention longer, in pretrial detention longer, and as a result, it contributes to the disproportionality of youth of color being detained when compared to white youth.
Next slide, please.
And so we really spoke to our community after the findings were released about what kind of resources do they need in order to advocate for their client's pretrial release. And we released our first toolkit, which is a right to liberty, resources for challenging the detention of children. Next slide.
And you can find both the these resources as well as the Right to Liberty National Report on our website at www.njdc.info.
And so 3 resources that we included in this toolkit is a right to liberty, the origin of bail, an annotated bibliography on the risk associated with incarceration, a sample habeas petition challenging the pretrial detention of children. And all 3 of those, the origin of bail and the annotated bibliography are contained within the toolkit itself. The habeas petition is on our website, and there's a link to the habeas petition through the toolkit.
Next slide.
And so resources for challenging the detention of children. We talked a little bit about the purpose of bail and how bail is a mechanism for ensuring a right to liberty. It provides for a release opportunity, and it preserves a presumption of innocence. So at common law, bail was a surety. It was a pledge or an assurance that somebody would return to court, and someone's promise was enough to meet that goal. More recently, bail has been used or has been understood to be some kind of financial obligation where a young person or their family has to give up a certain amount of money in order to obtain release that they then get back if they return to court. But that was not the purpose of bail. And we really created this resource to remind our community of when they're advocating for release, to go back to what the purpose of bail was. And if you can meet that purpose through other conditions of release, then that should be advocated for rather than a monetary amount. Next slide.
So as we engaged in this project and really focused on cash bail in juvenile court, and we spoke with a lot of our community members across the country, what became really clear to us was underlying this conversation of cash bail was, of course, the grave concern about incarceration in this nation. And as all of you know, the United States incarcerates more young people than any nation in the world. And what our community said to us is, we are really interested in a series of resources that you might be able to develop that can strengthen the advocacy that we do to really ensure that young people remain in communities, but that also can be used to educate decision makers about allowing young people to stay in their homes and communities. So the second resource that's in this toolkit is an annotated bibliography on the risks associated with incarceration. And we're really excited about this bibliography and the pieces of research that are included, because a number of the articles in here are not pieces that those of you who've been working on reform, who've been working in juvenile court for years, have been really on the forefront of the conversations. Those of you who work in juvenile court know in court, when decisions are being made about whether a young person is held, focus is often on risk of the young person being in the community and danger to themselves or danger to others. In many of the detention statutes that we looked at across the country, you look at those factors and often you see risk to self and risk to others. What you don't often hear in those detention proceedings is a discussion about the risks associated with detaining young people in those facilities. So this annotated bibliography provides for all of us a series of research articles that we can use in our frontline detention advocacy as well as our policy reform. So we're going to focus on a few of those things. Next slide, please. So the three key areas in the bibliography focus on: one, risk of victimization. Anissa's going to talk about that in a few minutes, but it really looks at what type of victimization occurs to young people when we choose to place them in facilities. Two, risks to their educational opportunities. Again, when we're thinking about removing young people from their communities and homes, are we considering the loss of educational opportunities and really the negative impact on their educational outcomes? And three, the risk of long-term physical and mental health issues. Our decision makers, are we thinking about the long-term impact that incarcerating young people has on their mental health and their physical health? And we're going to start with this last piece. So next slide. So what you'll see in the bibliography is a research study that was done by Varner, Dudovitz, and Nelson and Coker. And the title of the research piece is "How Does Incarcerating Young People Affect Their Adult Health Outcomes?" What's so interesting to us in the advocacy community about this piece of research is that it came out in 2017, but it's based on a longitudinal study of adults. And it looked at over 14,000 adults and asked them questions about their experience with incarceration. So a little bit less than 15% of the adults who were in this study had experienced some incarceration when they were a young person. And the results are really important for all of us who are considering the impact that locking up young people has on their lives. So what they found is that a young person in their adulthood who was detained for even less than a month, so it could have been a day, had an increase in depressive symptoms. So the notion that sending a child away for, a weekend of quote unquote preventive detention is a good idea. Let's think about the increase in their adulthood for depressive symptoms. So that was the first finding. The second finding was that if a young person is detained from anywhere to 1 month to a year, that there's an increase in the likelihood of worse general health conditions, meaning that in adults who spent anywhere between a month and a year locked up, they'll have worse general health. They'll get sick more often. They're more susceptible to viruses. You'll see greater long-term health care issues in that population. And then for those who were incarcerated for greater than a year, they see general health functionality limitations, meaning things like their ability to take care of themselves, walk up a set of stairs, are lower than people who have not experienced detention for more than a year. So functional abilities were impacted, depressive symptoms were increased, and in this population, they also saw an increase in suicidal thoughts. So when we as decision makers are looking at young people facing detention, it's critical that we remember that we lock up more children than any place in the world. It has a long-term impact on their physical health and their mental health. And now Anissa is going to talk with us about some other things we really need to be aware of when we're thinking about risks related to incarceration.
Next slide, please. And so one of the other things we have to take into account is a risk of victimization. When understanding the prevalence rates of young people who are detained, we know that 92.5% of them had at least one trauma in their life, that they have more exposure to violence, child maltreatment, victimization by peers, than other young people that are in the general community. And so while taking all of this into consideration, we looked at two studies, one on assault, robbery, and theft, the other in sexual victimization for youth in facilities. And according to the findings of one of the report, 29% of youth in custody reported that they were beaten up or threatened by other residents or facility staff. It's the largest study based off of youth in detention and custody. It focuses on both pre and post adjudication facilities. For the purposes of this conversation, of course, our focus is on pretrial facilities. But other relevant findings were that 10% of youth in custody said that somebody used force or the threat of force against them, that they were victims of theft while in the facilities, that 46% of them reported that they had their property stolen. 9.5% of them reported of experiencing at least one incident of sexual victimization. And so while we're looking at our prevalence rates and we're keeping in mind the findings and the risk of victimization, we also have to understand that the history of our clients of youth in detention facilities could lead to more exposure. The fact that they have been exposed to some level of trauma, sexual victimization in the past, the exposure while incarcerated of more opportunities where that they could be at risk for victimization could be triggering or re-traumatizing of youth themselves. And not only experiencing these could lead to a risk of victimization, just the knowledge of that. So we know if young people are aware that other people have been victims in facilities and have witnessed these, then just being in fear that it could happen to themselves also could lead to exposure to the risk of victimization.
So those are some of the resources, and Anissa's going to talk about a final one. And again, just a reminder that these resources and advocacy pieces are intended to really inform the conversation about money bail, thinking about the fact that it really shouldn't be used to keep children in detention. So here's a final advocacy piece from Anissa.
And so the last resource in our toolkit, so we understand what some of the problems are based off of the snapshot that we released. We understand the risk associated with incarceration and the prevalence rates of the young people detained. So our defender community really wanted to know how they can fight back on, so the bail hearing happens, your client is held on unaffordable bail. What do you do as a result? And one of the best strategies we found are filing habeas petitions challenging the pretrial detention of children. So we focused on case law and statutes based in Oklahoma, which is one of the 19 states and territories that currently expressly allows the use of money bail in their jurisdiction. But that language can be replaced with local statutory language and case law analysis from local jurisdictions. And if defenders in these communities need help finding that language, please contact NJDC. We're willing to offer technical assistance to provide that information. And this is also located on our website, and there's a link to it on the toolkit. And so we built these resources looking forward to partnering with our community to really fight back on pretrial detention due to unaffordable bail in the delinquency courts. But we really have so much to learn from our adult community and a lot of the work that Pretrial Justice Institute is doing.
So back to Megan.
Thank you so much. And if anybody has any questions for Anissa and Marianne, please feel free to put those in the chat box. Or if anybody is calling in and has computer audio and would like to be unmuted to ask their question, please feel free to raise your hand and we'll be happy to do that. One of the questions that I had, Anissa and Marianne, was, do you know of the states that you looked into their statutes? Has anybody been doing research on the outcomes related to money bail and whether or not there have been new arrests or whether or not individuals are more or less likely to come back to court when they have a monetary bond compared to other conditions of release?
So the issue of really examining the impact of bail is pretty new in the delinquency court arena. So looking at data on whether or not young people are coming back who've actually posted bail, we're not sure of. We do know in places where bail is used regularly that there is a less likelihood for there to be an ability to pay hearing. So what we've learned thus far is that where bail is used, it is many times unaffordable bail. So looking at data on whether or not it's an effective strategy, we don't have.
Great, thank you. I had a feeling that that was the case, but was wondering if there was anything that we hadn't seen. We do have a question coming in the chat box of what is a typical amount of bail for a juvenile case?
I mean, it varies by jurisdiction. In Oklahoma, we've seen as high as $500,000 that either a young person or their family is required to pay. We've seen other low amounts of $100, $200, $300, and then anywhere in between. The one thing to really note about delinquency court is that as Marianne mentioned, there's usually not a hearing based off of the ability for the young person or the family to pay, but also young people don't have their own sources of income. So any bail amount, even $100 bail amount, is something that's likely that a young person cannot afford to pay without familial support. And often they're not looking at the families to find out what they can afford to pay when making these determinations.
Thank you both. And another question, knowing the impacts of bail on young people and the family, have any states that currently used bail expressed reforming their practices for young people? So are you seeing any movement towards reform?
So in the early stages of movement, we are currently speaking to local jurisdictions in a number of states in the country about what kinds of reform would look like. Some are looking to make legislative reform. Others are looking for something that is less.
Some are looking at detention statute reform, actually. So recognizing that the legislation related to bail can be complicated. Some that are focused on the impact on young people specifically are looking at actually whittling down the opportunities for allowing young people to go into detention so that bail actually would be the default mechanism less frequently.
Thanks. And one more question that came through in the Q&A box. Can we use the habeas motion to challenge juvenile detention pending trial even if there is no cash bail, or should we use the risks associated with incarceration to challenge detention pending trial?
Oh, absolutely. So the initial habeas that I based that off of, I had two versions. One was on unaffordable bail, and the other was holding someone in detention without any option for release, so denying bail completely. So yes, the arguments contained within the habeas can be used for both, and it could be tailored. And really, the unaffordable bail part of it, we're really using the held without bail option and making a connection. So there's no, that we know of most states, and so if bail is excessive, it's unconstitutional under the 8th Amendment, but as we know, bail is really hard to argue for a constitutional argument. So making an analysis to just denial of any options for release is actually a stronger way to argue against it, but because it's based off of exactly that, a denial of bail completely, then the habeas can be used for both.
And we would say, of course, the risk associated with incarceration research, we would hope that will be used prior to a young person's detention and holding and being in custody. Right? So we hope that those are effective. If you lose there, then file the habeas petition, still use all that research in your habeas petition, but couple them, and we think it's even stronger.
Yeah, and in most states, and I'm sure this is not true for all, if the habeas is granted, it moves into a de novo bail review hearing. So even if you, for whatever reason, you didn't have an opportunity to use that research in the initial bail review hearing, you now have the opportunity in this new bail review hearing.
Thank you so much. And one more question in the chat box. Is there any relation to age in the use of bail, or is bail used more often for older youth, or is it more geographic?
I'm not sure if that came up in our study at all.
So for sure it's geographic because it's only even allowable in 19 states. So definitely there's a geographic context to it, but looking at when bail is imposed, we actually did not ask questions about age of youth, but it's a really good question to ask.
Okay. Thank you. All right. So I'm going to move into some of our lessons learned from the adult system, but please keep those questions coming in the chat box. So at PJI, we've been doing work on this topic for over 40 years, and the first 30 or so years were pretty quiet. And then over the last 5 to 10 years, there's really been an explosion of interest in pretrial justice issues, both at the state level and in a lot of local jurisdictions. So we've seen a growing grassroots movement around the issue of money bail, and a lot of reforms that have resulted, ranging from individual elected officials making commitments to change their practices around the use of bail, all the way up to changes in state constitutions and statutes and court rules. And there have been some successes that are related to that, and also some unintended consequences of those changes. So I want to talk a little bit about some of those things and pose some questions to all of you about what the implications may be for the youth justice system. Next slide, please, Beth. So we do know on the adult side that money bail is ineffective. There's not a lot of research, as Marianne and Anissa mentioned, on the youth justice side about whether or not money bail achieves its intended goals. But in the adult justice system, explicitly, we're trying to get people back to court and maintain safety in the community while they're released. And we don't have any research showing that putting a monetary bond amount on an individual achieves those objectives. But we do know that a monetary bond can result in longer detention for an individual, or that person just never being released pre-trial. So similar to the results that were discussed on the youth justice side. So if it's not effective in achieving the goals of release, and it's not effective in making sure that detention is the carefully limited exception that it's supposed to be, then there's really not a function that it serves in the system. And if we're able to reach those conclusions on the adult side, there's no reason to believe that we would not have similar results if that research was done on the youth justice side, though in those 19 states, it's definitely research that's needed. Next slide, Beth. And so in terms of drivers of money bail reform, there's certainly the legal and constitutional questions that are raised. There are the research and public safety and court appearance outcomes questions that are raised. And there's also been the question in a lot of communities around jail crowding and looking at whether or not the use of money bail is a significant driver of mass incarceration for pretrial populations. And on average across the country, jail populations are about 67% pretrial individuals. And a lot of those people are in jail because of a monetary bond that they can't afford. And 95% of the growth in jail population since 2000 has been because of unconvicted people and not being able to post monetary bonds that are being set by the court. So for those of you that do have money being used in your youth justice system, a really important question to ask is, of those individuals that are in detention, how many of them are there because they can't post a monetary bond, and what are those bond amounts looking like? In a lot of adult systems, we find that it's relatively low bond amounts, and as Anissa mentioned, the threshold for what a child can afford or what their families can afford is probably even lower. And so are there very low money bond amounts that a court may have thought would facilitate the release of a child that are actually leading to their detention, and do you have analysis of that? This can often be a surprising number for communities to look at, and a real drive to change the way those money bonds are being used. Next slide, please, Beth. So when you have money bond in statute, a lot of times the most obvious fix would be to go in and change the statute. And this has happened in a few states. We have states like New Jersey, where money bond wasn't completely eliminated in statute, but it was significantly curtailed. And New Jersey also made a change to their state constitution to put preventive detention measures in place, so an option to allow people to be detained without money in the system. And then we've also had states like New York and California who have legislation that is passed that has not gone into effect yet, that is moving away from money bond completely. Statutory change is definitely a great option, but it's also important to look at potential unintended consequences of those changes. In California, SB 10, which passed last year, is going to a statewide referendum in 2020. And one of the concerns about SB 10 is the fact that there is a significant detention net. There's lots of opportunity within that statute to increase the number of people who are being detained without bail, and questions about how that conflicts with language that's in California's constitution. In New York, there was a lot of debate about adding the ability to detain people preventively based on public safety, because New York statute currently only allows court appearance to be considered in pretrial bail decisions, and that change was not made. So it's still the case in New York that people making bail decisions are only considering whether or not somebody will appear for court, and there's not an option to detain those individuals based on public safety. I have a resource here from the Cattell Center for Health, Equity, and Justice. They have a lot of great resources on their website, and they also did a University of Pretrial webcast that we've got recorded talking about that process of statutory change in New York and its potential implications that would be great for you all to check out. But given the fact that in a lot of states, what we call the detention net, the criteria for being able to detain youth is broader than it is for adults, it's really important to keep an eye on whether the proposed changes to the monetary bond system would potentially result in more opportunities for young people to be detained rather than less, and just shifting one thing for another. Next slide, please, Beth. And even in states where money bonds are available by statute, it's very rare that they're required. So there's usually a lot of room within current statutory frameworks to change the culture in courts and the way those money bonds are being used without needing to make any changes to the statutes. And New Jersey is a really great example of this. They did change their state statute, but there's still room for monetary bonds to be used. However, there was a lot of work done in the court system before those changes went into effect to change the culture around the use of money and to do a lot of education demonstrating the fact that monetary bonds were not effective in being able to get people back to court or maintaining public safety. So when their law changes went into effect, money bond went from being the ubiquitous condition of release to going down to just a handful of bonds that are being issued across the state in any given year. And now that we're a couple of years into the changes in New Jersey, we're seeing that there was not a negative impact on public safety as a result of those changes. There was not a negative impact on court appearance, and the rate of citation release with law enforcement went up significantly. So you have a lot of folks that are just never coming into the jails in the first place because the likelihood that they were ultimately going to be detained was pretty low anyway. So New Jersey is really the example we hold up of the benefit of spending a lot of time and energy making sure that the folks in the court are educated, and there's really a change in the perception about how money bonds are used, and there's lots of opportunity for this in the juvenile courts as well. But as we all know, changing culture is hard, it takes time, and there's really a concerted effort that needs to go into that to be able to make sure that those changes are put in place. But a lot of you on the line who've worked in JDAI, who've worked in other adult justice system reforms, have done this work and have experience with what you need to do to be able to change culture around the use of jail and around the use of juvenile detention. And this could be the next layer of that work if money still plays a role in your system. Next slide, please, Beth. And we've also seen a significant uptick in the amount of litigation related to money bail over the last several years. And a lot of that litigation has been successful, and concerns about being the next target of litigation has driven proactive changes in a lot of jurisdictions. We've seen this litigation be successful on several fronts. The first is around habeas petitions, as Anissa and Marianne were mentioning, and looking at people who are remaining in detention even though they've technically had a bond set because that bond is unaffordable. There have been a number of challenges to bond schedules under the 14th Amendment protections around due process, saying that basically you are discriminating against certain groups based on their level of wealth, and you're not making an individualized bail determination by just saying, oh, because you have this charge, you have this certain bond amount that's set on you. And so a lot of jurisdictions have had to move away from bond schedules as a result of those challenges. And then recently in Louisiana, which is the case that I have pulled up here, in federal court, there have been some successful challenges around conflict of interest when fees related to monetary bond are being used to fund the court, that the courts in setting those monetary bonds have an inherent conflict of interest because they derive a financial benefit from that money bond system. So this is going to have ripple effects around the state of Louisiana, which is one of the states that allows the use of monetary bonds for young people. So a question you can be asking yourself is, would your state's current practices and your statutes hold up to this legal scrutiny if litigation were to be expanded? And the fact that we've got some lawyers who are interested in this question may mean that there's some litigation potentially coming down the pike. And this may be an avenue to put some pressure on your system to change as well. And Civil Rights Corps and Equal Justice Under Law, the Southern Poverty Law Center are all groups that have been very involved in those lawsuits, the ACLU. So those are all resources to check out if you'd like to learn more, as well as our resource library on the University of Pretrial. We have a lot of the decisions in those cases archived for anybody that wants to take a look at them. And one of the solutions that's been proposed in a lot of jurisdictions related to that question of unaffordable bail is adding a ability to pay determination as a step in the process. So saying we're going to find out what an individual can afford to make sure that if a monetary bond is set, that they are able to be released. Some of the questions with this is the fact that it's not a yes or no question. So in the way that when indigency is determined for the purpose of appointing counsel, it's like, all right, there's a certain threshold. Yes, you get a public defender, or no, you do not. There's no best practice for how you answer the question of how much can this person afford to pay? Is this how much can they afford without going bankrupt? Is this how much can they afford while still paying their rent and paying to feed their families? There's no good way to tell what an affordable bail should be, and not necessarily agreement in the field about what that should look like. So that's the first issue. And the second issue is that that doesn't make money bond effective. Just because you've determined an affordable amount, that person is still having to pay that amount of money, and without that increasing their likelihood to come back to court or increasing public safety as a result. So this is a stopgap measure that is facilitating release in some communities, but it doesn't address the underlying issues that come from the money bail system. And as was mentioned earlier, how would we decide what this looks like for young people? They're not paying their own money for these monetary bonds. And is their family's income considered in this? Is this how much, whatever their caretakers could pay to be able to facilitate their release? So when we look at it in the youth justice system, it makes even less sense to be thinking about an amount that somebody could potentially afford to facilitate their release. And back for 1 second, please, Beth. I just wanted to point out this resource that's on here. The question of bail bondsmen and commercial surety comes up more on the adult side, but this was some research done by Joshua Page and his colleagues from the University of Minnesota, where he actually embedded himself as a commercial surety agent for a few months and talked about some of the tactics that are used to pressure family relationships in being able to put forward bond amounts, and the ripple effect that monetary bonds have on the loved ones and the support networks of individuals that are being asked to pay these bonds. And I'm getting shivers up and down the back of my neck as I'm talking about this study. It's something that I would really encourage all of you to read if you want a better understanding of the impact that monetary bonds can have, and the emotional pressure as well as the financial pressure that it exerts on people that have to pay them. It's a great piece of research to read. All right. Next slide, please, Beth. And another strategy that has been really effective in some communities, Chicago specifically, is volunteer court watchers who are actually going in, watching bail hearings, and seeing if the judges and the magistrates are abiding by either the settlements in litigation or court rules or statutory changes. I only mentioned court rules briefly, but in some states like New Mexico and localities like Cook County, changes to monetary bail practices have been made by changing court rule. And the results often show a wide variation by courtroom in a way that looking at the average release rates or the average use of monetary bonds in a jurisdiction may not. And it has led to transparency and accountability in those systems. And obviously with the different levels of access to juvenile courts compared to adult courts, it's not as feasible to say we're going to get together a group of community volunteers to go in and watch and make these decisions. So this is an important question to ask of, if these policy changes go into place, who are the folks who are in a position to collect data and to hold the system accountable for changes that have gone into place, or in jurisdictions where changes have not gone into place and you want to get a really good picture of what's actually going on, who's in a position to be able to secure that access as well. And your juvenile defenders may be a natural answer to that, but others in the system can potentially play that role as well, to be able to get a sense of what are the behaviors in courts and do we really have a good sense of what's going into those bail decisions and what are the results that we're seeing in individual cases. So those are a lot of the things that we've been seeing on the adult justice side, that as this work is moving forward, we really encourage a state and local combined approach wherever possible, that there's lots of opportunities from the grassroots level and in individual local courts to be able to make some of these changes, and for attorneys, for judges to make a commitment to changing their own practices to be able to move away from money bail. But there's also a lot of opportunity for changes at the state level as well, and making sure that thoughtful changes to state statutes, to state level court rules where appropriate, and potentially to your state constitution, depending on how it's worded, all provide an opportunity to move away from systems that are just driving unnecessary detention, driving racial inequities, and a lot of the problems that we're all committed to solving in our adult and youth justice systems. And I'd like to open it up there for any questions on what I shared, but also any lingering questions for Anissa and Mary Ann as well. All of the resources that were shared in both of those slide deck presentations are available either through JDAIconnect or the University of Pretrial, and you can feel free to reach out to any of us if there's anything specific that we shared that you definitely want to get access to. And also put in the chat box if anybody's interested in joining whichever community you're not in to join JDAIconnect. It's just www.JDAIconnect.org. There is a couple of step process that you do have to go through to set up an account in JDAIconnect, but we promise that it's worth it once you get in there. And if you're interested in the University of Pretrial, it's university.pretrial.org. And we would love to see you in either place. And Mary Ann and Anissa, what is your website for folks that want to check that out?
It's www.njdc.info, I-N-F-O.
I'm glad I asked. I would have missed that last part.
Yeah, it's a funny exchange. But Beth and Megan, we can also make sure that you have links that you can post on your sites for the two reports that we talked about today and the other resources related to youth bail.
Awesome. And I love the interactive map that you have on your website of the states that do allow monetary bail. So for anybody that answered, I don't know, at the top of the webcast about whether money is allowed in your state, please feel free to check that out. Usually one of the most difficult hurdles for states that are first exploring their bail statutes is doing that analysis and figuring out what do the statutes say, what does the state constitution say. So folks who are doing this on the youth justice side, you guys have put them a step ahead by doing that analysis in the first place. So thank you very much.
And here's a question for all of the panelists. What advice would each of you give to people on this call who might be interested in addressing money bail? So I think that's got implications on the juvenile side and the adult side. So because of my preferences, let's start with the juvenile side.
So as Anissa said, we have a lot to learn from what you guys have been doing on the adult side, and it's been really interesting for us. What Megan talked about later in her presentation, just making sure that we're actually not net widening in the reform, and being sure that we're really looking at, for us, it's a combination of both what the application of money bail looks like in juvenile court currently, as well as what the detention statute currently looks like in the state, and thinking about what our end goal is. Our end goal is ensuring that young people are able to stay in communities and at home, and that money bail is not used as a way to limit release. So if that's our end goal, what are the things that we can do to ensure that money bail isn't being used to detain children, but in that the effort to reduce the use of money bail, we're also making sure, as I said before, we're really limiting the opportunities for young people to actually enter or detention to be used to remove young people from their homes and communities. And, you know, if there are folks on this webinar or other community members that are interested in, we would love to talk with you about your interest in reform. We're learning a lot as we go through this process about state statutes. The piece of the toolkit that comes next is we've done an analysis of all 50 state detention statutes and looking at the provisions within those, looking at next to bail and trying to figure out based on community input and interest, what would next steps look like in terms of this reform?
And Megan, on the adult side, same question.
Sure. So I think there's a couple of different avenues that you can take. There's folks working on this issue in most states around the country right now. So I would encourage you to check in with your national professional organization, since a lot of the national professional groups have position statements on money bail or may have some resources available to you. And then to check out whether you've got any organizations in your state through social media or through direct contacts that you have that are already doing work on money bail issues. There are a lot of states that have started bail funds as a stopgap for being able to get money bail posted for individuals as a way to be able to ensure their release even while we continue the fight to just get the money bail out of there in the first place. There may be grassroots organizations that are doing court watching initiatives, and there have also been a lot of states that have Supreme Court task force or other groups within the courts or within other branches of government that are looking at this issue. So there may be some existing infrastructure that you can join onto if you're interested in this. And we have a lot of resources on the University Pretrial, and in both JDAIconnect and UP, you can just post something in the community. If you're saying, hey, is there anybody else that's working on XYZ issue in my state, to try to connect you with somebody else, we can probably help find you a colleague that is sharing your concerns and is interested in doing some of this work.
I'm looking at the chat box and I'm seeing a pretty shy crowd at the moment, but I do have one other question that was submitted beforehand. So I'll ask that, but again, encourage people that if they have some questions for our panelists and subject matter experts to go ahead and put those in the Q&A or chat box. But while they're thinking about their next question, here's one for all three of the panelists also. Are courts in a place to move away from money bail completely with the authority that they currently have? To be fair, we're going to start with Megan this time.
I think the short answer for that is yes. That even in jurisdictions with bond schedules, like under current California law, there's a requirement that county courts have a bond schedule in place. There's no requirement that, for this particular charge, you need to use the bond schedule, and judges have discretion in virtually all circumstances to deviate from bond schedules if they are in place. So there is a lot of room to be able to move away from the use of monetary bond. And there have also been a lot of prosecutors who have made the decision that I'm just not going to ask for a monetary bond in the case where I've got the potential to put that request before the courts. And there's also a lot of room, as Anissa and Marianne mentioned, for defenders to vigorously argue money bonds being put in place. So there's a lot of room within current statutory frameworks for that to happen. And even if it's not a decision at the level of state court rules or leadership from Supreme Court, so that is certainly happening in some states as well. It's a local decision that even we're hearing from some municipal level, district court level judges who are just like, I'm just not going to do it anymore.
So on the youth court side, I think the answer is similar, that there is a lot of discretion in decisions that are made about detaining young people and administering a decision about bail. Certainly, as Nisa said earlier, bail was intended as a mechanism for release. And the idea was that there should be a strategy for allowing people not to be detained, and that really the only consideration was supposed to be, is this person going to return to court? So when we think about juvenile court, especially, if there's no history of a young person not appearing or fleeing, and we can look at that history of that young person, then our community is really trying to evaluate why are high bonds being set for young people when we know, in fact, that really is simply a decision to detain a young person. Young people don't have their own incomes, and so and within our community as advocates, we can certainly make arguments about high rates of bond that are set in court. There is a lot of discretion from the bench, but there also, as we see the use, it's really varies from courtroom to courtroom. So as Megan said, what you're seeing on the adult side, it does seem to be a local issue. Of course, it does reflect whatever the state law is. But I do think that a lot of progress can be made without having substantial law change. That being said, where there's an interest in making changes, law reform, of course, is a solid strategy to get change done.
And can I just make one other point that I don't know that we've made explicitly over the course of this webcast? So like the supposed logic behind money bonds is that it gives somebody skin in the game, and that because they have put down this money, that it motivates them to come back to court. And the idea that if a child's parents pays an amount of money, that is in their adolescent developing brain going to make them say like, okay, because this monetary exchange has happened, that means that now I have to be committed to coming back to court when I wouldn't have been otherwise, and I have to be committed to not doing anything else wrong while I'm released when I wouldn't. It just doesn't make any sense from what we know about adolescent brain research and just the behavior of the youth in our justice system. The idea that we would put that kind of provision in place doesn't have any logical support behind it, even exclusive of all these legal arguments and research-based arguments that we're making in this conversation.
Yeah, I mean, I think as Anissa stated earlier, I think the idea of money bond that becomes the family's responsibility actually has the impact of having young people relinquish their rights and protections. So it's more likely that they are feeling badly that their family is putting a mortgage on their house, or have to make choices that they can't do this for one child because they have to do this for the other child. We know it doesn't have a good impact in terms of their ability to make effective decisions about their legal rights, the protections, the process, and the idea that it would be a deterrent or some type of incentive, I think is counter to what we know about young people and adolescent development.
And to expand on that, some of the findings or some of the defenders in our community reported back that oftentimes young people they stayed detained because their family couldn't afford to pay, and that broke down the relationship with their families. That my parents don't care about me because you're not paying this amount of money to see for my release, to have me come home, and not understanding other financial obligations that their family has and why they can't afford to do that.
Well, and that is without, as we all know, bail is so complicated, right? So how much money are people actually paying, and how much money are families required to pay? So what young people understand about that complex system of money down, money owed, money promised, I think makes the whole situation of cash bail in juvenile court a really complicated alternative. And without the intended, what we believe is the intended original idea of bail, which is to allow for release.
So we have 2 minutes remaining and we have 2 questions. I'm just going to say that we're not going to get to both of them, but we are going to follow up with the questions of the communities. But let's go ahead and in a minute try to answer this one. How do we argue that the community is safer for the child than detention, especially if the judge knows the community has a lot of crime and drug activity? Any ideas would be appreciated. Again, not trying to mute anybody, but we really only have a couple minutes.
I'm hesitating in answering that because my pushback would be that does the community actually in fact have a lot of crime and drug activity, or is it more often just an over-policed community, right? So one of the things that we've been working with defenders' offices, especially public defender offices that have a large percentage of the representation of young people, is to start keeping data and statistics within your own offices. So are you tracking zip codes and where arrests are taking place? Like, is there in fact higher crime, or are there more lower level offense misdemeanor arrests taking place because youth in that community are just being watched more by police officers in other communities? Like, start tracking this data and start bringing this up in those detention hearings, bail review hearings, and pushing back on some of that data that the court keeps referencing, because that's probably not what you're finding when you're looking across the board in your own communities, when looking at arrests that are taking place and the clients that you're representing. So one of the ways that you can push back on that is tracking your own data and referencing that data. Other ways you can push back on that are finding alternatives to detention within their own communities. That community engagement is one of the ways that to promote positive development in young people, and to argue why removing that young person from that community is so detrimental to that development, and how finding community support is actually a stronger alternative than detention.
Yeah, and really just flipping the narrative on its head, as we said earlier, right? So we know that there are supports within communities, and oftentimes the court is focusing on only those things that they see in the arrest reports, and they're not focusing on the great strengths that we know are in the communities where young people are living. So I think it is on us as advocates to make sure that we're surfacing those and bringing them into court decision making.
Well, unfortunately, thank you both. Thank you all three. But that's all the time that we have today. We are going to post this recording on JDAIconnect and the University of Pretrial. But I want to thank our panelists very much for participating. And Earl, I see your question, and I appreciate it. And we're going to follow up with that on the community too. I didn't want to think that we were ignoring that at all.
Yeah, we're happy to keep this conversation going in JDAIconnect and up in the discussion thread. So please bring more questions if you have them.
Okay,
Thanks,
so
everybody.
with that, thank you, everybody. Look for the recording in each of the communities we've talked about. Everybody have a good day. Thank you.
Thanks, Beth. Thanks, Marianne. Thanks, Anissa.
Bye.